Start. While deciding the substantial question of law on which the appeal was admitted, the court found the illegality committed by the court below, since the identity of the land in question was not ascertained, and accordingly, it formed an opinion that the court below had erred in law in decreeing the suit without getting the property in dispute identified stop para. The perusal of judgment discloses that the court did not frame any other substantial question of law and had decided the appeal only in the question of law so framed at the time of admission of appeal, and therefore, there does not arise any question of compliance of proviso to section 100 under bracket 5 of CPC stop para. The judgment relied upon by the learned counsel for the applicants in the case of Lisamma under bracket supra on the point that question of the identity of property is a question of fact is not applicable in the facts of the present case stop. Since the court has not framed any substantial question of law regarding the identity of the land, the court, while deciding the question of law on which appeal was admitted, found illegality committed by the court below in not getting the land identified while decreeing the suit stop para. It is settled in law that court can exercise its power of review only when there is an error apparent on the face of the record, and an error which is to be fished out by a process of reasoning cannot be said to be an error apparent on the face of the record stop. Hence, it implies that the reviewing court has no power to review the judgment where the error in the judgment is to be searched out by a process of reasoning stop para. This court is of the opinion that to test the aforesaid contention of learned counsel for the appellants, a process of reasoning has to be applied which is beyond the scope of review, as under the power of review, the court cannot rehear the appeal stop para. At this stage, it would be relevant to note that the appellants have taken specifically in paragraphs 17 and 19 of the written statement wherein they have disputed the identification of land, and further, they have filed an application before the appellate court, which is marked as paper number 74, praying for the survey of the land in question, and thus, the submission of learned counsel for the applicants that identity of land was not disputed by the applicants is incorrect on the face of the record stop para. Now, so far as the submission of learned counsel for the applicants, that court did not frame any substantial question of law of remand, it is pertinent to note that no ground has been taken by the applicants in the memo of review petition that no substantial question of law of remand was framed, accordingly, the judgment under review is not sustainable stop, as no such ground has been taken by the applicants for reviewing the judgment of this court, therefore, this submission cannot be advanced during the argument stop para. It is worth mentioned that the court ought to have framed any issue of remand or not can be adjudicated only after hearing the applicant's stop.